Hi again, everybody. I'm Rob Rosenthal with AskTheLawyers.com, and this is another episode of Ask the Lawyer. So sometimes after a divorce has all been worked out for one reason or another, one of the parents decides they want to alter the custody arrangements. Well, today we're going to ask the lawyer, how complicated is this in the state of New York, and how is it done? And so here to answer our questions is Chaim Steinberger. He's an attorney, a divorce and family law attorney in New York City. Chaim, thank you for making some time for us today. I appreciate it.
Good afternoon. It's my pleasure to be with you, Rob.
So when is it allowable to change what has already been decided, to change the custody arrangements?
So there are a couple of really important principles when talking about custody. The first important principle is that we always look to the best interests of the child or children. So it isn't what you want, it isn't what the other parent wants, it's what's in the best interest of the child. The second principle I want to point out is that there's a strong emphasis by the courts on the stability. So whoever the children have been with, the courts are somewhat reluctant to make a change because that serves as another upheaval for the children. So when you go in for a change of custody, there's that burden to overcome too. Now we're destroying the stability. Children have been through enough with the breakup of the family, the parents splitting apart. Now we want to sort of change it again. So that's a second strike against it. Then there's another thing. If the judge has had a trial and has made a decision that one parent is the best parent, the children are better off in the custody of one parent, to undo that and start all over again, there's a certain presumption in the system that once a decision has been made, you don't like the decision, you go up on appeal, but it's been set and we don't redo it over and over again. Conversely, if it wasn't a decision by the trial court, but rather the parents made an agreement that one parent would have custody, then the first question the judge would look when two parents come back into court, the judge would lower the glasses and look over his or her glasses and say, what's changed? 6 months ago, a year ago, 2 years ago, you both agreed that the children would be better off in so-and-so's custody. What has changed? So in order to bring a custody modification petition, now, custody is one of those things that are never set in stone. The courts act as parents patriae, as the super parents, the Lord protector of these children who are powerless, who need the protection of the official, and in this case being a judge of the Supreme Court or a judge of the family court, who throws their cloak of protection over the children. And so the courts are always going to look at what is in the best interest of the child. And so therefore, no custody award is ever a permanent award. But these are some of the hurdles that you have to overcome, that when you come into court, if you're planning to mount a custody challenge, you have to be sure that this is going through the judge's mind, and you will have to have good answers for all of these questions. And if you are the parent trying to prevent the change of custody, you have all of these presumptions working in your favor.
So with that being said, what are some, in the eyes of the court, some legitimate reasons maybe for requesting a custody change?
So it always, forgive me, I'm going to sound probably like a broken record today. It's always the best interest of the child. And so the one bit of advice I tell people is always, instead of framing everything in terms of what you want and what you'd like and what would be better, framing it from the point of view of the children. What would be better for the children? How will the children be better off? So if a parent comes into court and says, Your Honor, the custody arrangement that's been existing until now isn't working for the children, that's the trigger that allows you to now go and ask for a modification of the custody. So then here's sort of the problem with the big issue of custody, whether it's an original custody order or a modification order. When you say what is relevant in a custody order, the answer is pretty much everything. If a child has asthma and a parent is smoking, then the parent smoking, Your Honor, that parent shouldn't get custody because he or she smokes in the presence of the child. So if you want to, all of your arguments you want to frame from the point of view not of what you want, but from the point of view of the children. And your argument when you walk into court has to be, this isn't working for the children. Now, what can that be? Well, if there was a joint custody order, the fact that the parents can't get along, if every time you need to make a decision, the parents can't get along, And the law in New York, under the leading case of Bremen versus Bremen, if the parties can't agree on who should get custody, how are they ever going to agree on whether the child needs the appendix removed? And so the court is duty bound to decide either one parent or the other. It could be something as slight as one parent moving in the right circumstances 20 miles. I think there was a recent case where a parent moved in Westchester from one side of the bridge to the other side of the bridge. As the crow flies, it was only 15 or 20 miles. Most people would think that's not a big deal, but during rush hour in that neighborhood, that's a 45-minute trip. And so that means that the children can't stay at the other parent's home and still get to school at time without having an unreasonable travel arrangement. So that might trigger a review of the custody orders and determination of whether custody has to be modified or visitation has to be changed to accommodate the new situation.
It sounds to me, especially if well, let's start off with if both parents don't agree. If one wants one thing, the other wants the other. Sounds to me this is the kind of thing you need to have an attorney to help you navigate, yes?
So you always, these are so complicated. I tell people the two things you hope never to need is a doctor and a lawyer. But if you need one, you need the best you can afford, because a bad doctor and a bad lawyer is worse than no doctor, no lawyer. So in custody, I say everything is relevant, but you need to know how to frame it. You need to know how to position it. A big mistake people make is they think that, oh, if the law's on my side, all I have to do is get up and say, Your Honor, 2 + 2, and the judge goes 4, of course. The practice of law is not arithmetic. Ultimately, really what the lawyer has to do is win over the judge's heart, mind, body, and soul by creating a theory of the case that makes the judge feel, not so much think, but feel that if the judge doesn't do what I want the judge to do, a grave miscarriage of justice is going to happen. So there are a couple of problems with a client sort of either representing themselves in court or waiting a while and bringing a lawyer in later. First of all, when preparing, there are things you can do to set up your position. So if you want to be clever, strategic about it, then you want to set up your case in such a way that by the time you walk into the court for the first time, your case is laid out for you. You want to always seem like you were the reasonable parent, and the other parent, you've bent over backwards, you've tried to reach an accommodation that was appropriate for your children, but the other parent just couldn't get along. And so there are things you can do ahead of time to set things up. You don't want to write. So there was an old saying that goes, dance like nobody's watching, work like you don't need the money, and love like you've never been hurt before. And we've now added a fourth one, which is write emails and texts as if you're going to have to read it in open court in front of the judge. Every text you write, every email you write, imagine you're going to be sitting in a courtroom with all the lawyers and the court reporter and the court officers and the judge staring at you and looking at you and going, you wrote what? And so you need to be very careful. Bill Eddy, a social worker and a lawyer, came up with this acronym. Whenever you're writing to your ex, use the BIFF method, B-I-F-F. Every email should be brief, informative, firm, and friendly. And then there's another acronym that I heard once. I loved it, but I can't remember it for the life of me. It's never be argumentative, never be defensive. So you might write to your ex saying, Susie has a class play at 3:00 next Tuesday. Beautiful, brief, informative, firm, and friendly. You don't want to add, and if you really loved her, you would show up on time and you wouldn't bring your girlfriend, then you won't try, and she's wanted you, but you missed the last 3. If you ever have to read that in court, and the likelihood is great that you will if it comes to custody battle, that will reflect poorly on you. So you want to start setting things up before you get into court. And now, as far as once you get into court, can a person do this themselves? It's too complicated. Here's the deal. Whenever public speaking, people say that public speaking is the greatest fear that people have. People are more afraid of public speaking than they are of dying. In other words, people would rather be in the coffin than outside the coffin speaking and making the eulogy. So it's scary enough, not really scary, but it gets the adrenaline pumping when a lawyer has to get up in court and make this argument on behalf of the client. Take that and multiply it by an order of magnitude, because now you have not only the fear of public speaking, but now you know that your derriere is on the line, and you have things that are so important to you. It's impossible for somebody to maintain their cool and collection and be able to do that. Now, in addition, when you're in court, you need to know the law, the substantive law. You need to know the procedural law. You need to know the rules of practice. You need to be able to frame it in such a way. My job as an advocate is to teach a judge. Judges don't become judges because they know all of the law really quickly by heart and they can make tough decisions really quickly. Judges become judges for a whole host of different reasons. It is my job as an advocate to teach the judge everything the judge needs to know to make the right decision. It's my adversary's job to teach the judge everything the judge needs to know to make their right decision. Now, can a pro se individual, a pro se meaning representing themselves, can they do that for themselves and be collected, be calm? Also, in court, we have our legal lingo, and people say things in shorthand, like in every profession. And so if you're not in it, if you don't know what the lingo is, you're not going to pick it up and you won't know the significance of it. And if you're going to learn everything you need to learn to do not an adequate job, but a really great job, then you may as well do it for a living. We lawyers have a saying, any lawyer who represents himself has a fool for a client. So even if you were the best lawyer, if you represented yourself, you're going to get yourself into trouble. I wrote a 20-page article on this, and I have the case of 3 really excellent lawyers who represented themselves in their divorces, and they got into a whole host of trouble because of it. So it's a bad idea. It's a bad idea for a litigant to go into court even by themselves, even for the first or second time, because every word you say in court drops and cements a post into the ground. So people have come to me later and they wanted me to represent them. And I came up with a whole bunch of really good arguments, but now I couldn't use several of them because you said this, that was inconsistent. You said that was inconsistent. So you want to, as in playing chess, you want to sort of have a strategy in mind before you make your opening move. Now, of course, it has to change. You have to be nimble. You have to be able to flex what I call the shifting sands of the battle lines of litigation. Mm-hmm. And it all changes. And so you need nimbleness, you need flexibility, you need creativity, but you want to have an idea. So going in there, sight unseen, without knowing the law, without knowing the facts, and being able to tie it all into a cohesive theory of the case becomes very dangerous.
It occurs to me too, your advice for how to write those emails also could be extended, I'm thinking, to social media, to be careful what you say about your the X on social media too.
Social media is a big problem. You want to be very careful. You probably don't want to say anything or post anything about the children, about the lawsuit, about the divorce. That becomes very dangerous. Remember, children only have one father and one mother. They'll never have another father. They'll never have another mother. You want to find a way to work together and work things out so that the greatest gift you can give your children is the gift of the permission to love the other parent as much as they love you. That's the greatest gift you can give your children.
It's very important information, some great information you gave us today, Chaim. Thank you so much for your time. I appreciate you answering our questions.
My pleasure, Rob.
That's going to do it for this episode of Ask the Lawyer. My guest has been attorney Chaim Steinberger of New York City. If you want the best information about family law, or you're ready to choose a lawyer that lawyers choose, make sure to visit our website, askthelawyer.com. Also take a second and subscribe to our YouTube channel by clicking on the button at the bottom of the screen. Thanks for watching. I'm Rob Rosenthal with AskTheLawyers.com.